I'm Drew Stevenson, and this is a video for my professional responsibility course about conflicts of interest. And here we're specifically talking about conflicts outside of the litigation context, or the non-litigation conflicts, as the model rules call them. And this is really dwelling on comments 26 to 28 for ABA Model Rule 1.7. So they give an example at the outset of non-litigation conflicts. Conflicts questions can arise in estate planning and estate administration. You may be called upon to prepare wills for several family members at once, such as a husband and wife. And depending on the circumstances, a conflict of interest may be present. So, in estate administration, the identity of the client may be unclear under the law of a particular jurisdiction. Under one view, the client is the fiduciary. Under another view, the client is the estate or trust, in other words, sometimes the heirs, including its beneficiaries. To comply with conflict of interest rules, the lawyer should make clear that what the lawyer's relationship is to the parties involved. And so, for example, you could have an adult who has an elderly parent who needs to have their will done and have their affairs put in order. So the adult child, right, who might be in their 50s or 60s, goes and hires the lawyer and arranges for them to do a will, basically for grandpa. And so we have a problem, right, that wills and estates generates a lot of malpractice actions if the lawyer does something wrong, and the will is held to be invalid, or if for some reason there's a problem with the distribution of the assets. And so the question is, can the heirs sue the lawyer? And originally at common law, there was a problem with what we call privity. That, well, the heirs didn't hire that lawyer, right? It was usually the person who's doing the will, the testator, we say, who's now dead, hired the lawyer. By the way, this is one of the reasons, besides the fact that there's so much at stake with inheritances, that a lot of times people had no prior relationship with the lawyer. The heirs didn't pick that lawyer. So they don't mind suing that lawyer when they are frustrated with their inheritance. So in the old days, there was a question of privity of contract, and because the heirs didn't necessarily hire the lawyer. And then again, there's the question of what happens when one of the heirs basically sort of facilitates the hiring. They're paying for it, but it's clear that the representation involves doing a will and doing estate planning for the person who hired the lawyer's parents. This is a very common scenario, and it can get very confusing later on if the will is challenged or goes through probate. And so there's actually a split of authority in the United States about whether beneficiaries have a right, some sort of legal claim against a lawyer for legal malpractice. Or if they don't, if only, let's say, the person who drafted the will, if they realize the lawyer made a mistake before they die, if they sue the will. And of course, then there's the issue of whether the estate can stand in the shoes of the person who has died. So you're going to have to look this up, but be clear about it, and then communicate whatever the rule is to the clients. Okay, so now whether a conflict of interest is consentable depends on the circumstances. So in transactional work, we have some non-consentable conflicts. So a lawyer cannot represent multiple parties to a negotiation whose interests are fundamentally antagonistic to each other. But common representation is permissible where the clients are generally aligned in interest, even though there's some difference among them. So again, to give the example of, so we're not talking about litigation, so we're going to go back to John, Paul, George, and Ringo come to you and they want you to help them set up their own record label. Well, as long as you explain to them what's going to go wrong in the future, that they're going to fight over the proceeds that they get, and also over control over decisions that are made. And it could also be over dissolving the partnership or getting rid of one of the partners who's gone rogue. All of these things can go wrong. Well, normally, though, when people come to you, actually their interests mostly overlap or are pretty aligned and all of these things are just risks. In fact, they might even be less than 50-50 risks or improbable risks given the circumstances, but they're still risks. So if it's still a risk, you get consent. On the other hand, there's times where you could tell that your clients come in to talk to you about going in on a joint venture, and they're already fighting. They're already at each other's throats. They're already screaming at each other. You try that and I will sue you from here to kingdom come, or something like that. Well, if you can tell that they're already fighting, they have kind of irreconcilable differences, and that it's actually probable that they're going to end up suing each other over this, then you shouldn't agree to represent them jointly. You can represent one of them, but you need to tell them that everybody in that situation, if they're already fighting over things that are kind of fundamental to the matter, that the legal matter of the representation, then they all need to have their own lawyer. Okay, a lawyer may seek to establish or adjust a relationship between clients on an amicable and mutually advantageous basis. Here's an example. You could help organize a business in which two or more clients are entrepreneurs. That's the example I've been giving. Working out a financial reorganization of an enterprise where two or more clients already have a stake. So let's say they have a partnership and they kind of want to redo their partnership agreement to allocate control or assets differently, or maybe because one of them basically wants to retire, wants out, or arranging a property distribution. One of them has died, and so we have settlement of estate in a partnership. And all of these things can happen, and clients may come to you to do that. So let's talk about comment 28. The lawyer will probably try to resolve the potentially adverse interest by developing the parties' mutual interests. In other words, find points of commonality or consensus between them. Otherwise, each party might have to obtain separate representation, with the possibility of incurring additional cost, complication, or even litigation, right? So in the end, if they have to, halfway through the representation, everybody get their own lawyer, it's probably going to be more expensive than if they had all started out with their own lawyer from the outset. And you should keep that in mind, and they should keep that in mind. So given these and other relevant factors, clients may prefer that the lawyer act for all of them, of course, right? That given those factors, they may still decide, well, it's cheaper to have you representing us. Now, I've broken this series on conflicts of interest into kind of short mini lectures, just trying to make a quick point, and that wraps up our initial lecture about the comments that deal specifically with non-litigation conflicts.